thank you so much. What a great panel. We're going to have time for some questions, and there's two microphones roaming around, but I have two clarifying questions I'd love to ask first. First, to Eugene, the one line of cases that you didn't talk about are the attorney advertising cases. The Supreme Court is particularly harsh on attorneys, and their theory is that they're trained in the art of persuasion, which is exactly what the marketers are. So I'm curious if you could talk about that.
Sure. Attorney advertising is constitutionally protected. There had been a long-standing, deep tradition, which was completely missing as to advertising of food, of totally banning attorney advertising. In fact, it was not only something that was just very broad, it was also very deeply embedded into the legal profession. As you'd think if there was be any kind of regulation that the justices would be particularly open to, it's the regulation that their bars had promulgated, and actually became very much a class issue. That, you know, if for whatever reason you were allowed to advertise and you did, that was very low class, very low rent. You're not our kind of person. Despite that, the Supreme Court has uniformly held that, well, the one exception is Florida Bar versus went for it, but it's a weird anomaly, but nearly uniformly and certainly quite broadly held that attorney advertising is constitutionally protected. Now, I did mention that misleading advertising can be restricted. The Supreme Court has understandably recognized that, you know, anything could be in principle labeled misleading, so there are boundaries to that. But in fact, if somebody, for example, lawyer says, "I guarantee results," well, that's not just misleading; that's a lie. No lawyer can do that. Likewise, there are limits to the way that the lawyers can portray themselves, can extol results in particular cases that suggest that that's going to end up being the nearly certain result in your case. But beyond that, lawyer advertising is constitutionally protected. So just to apply this to other advertising, look, if somebody says this cereal is fantastically good for you, it'll cure all that ails you, or even this cereal is much lower in sugar than other cereals, and it turns out that's false, or it turns out it's misleading because it's lower in sugar but higher in corn syrup, and that's not any better, then yeah, that could certainly be restricted. But I take it that that's not the advertising that really hooks the kids, right? No kid would want to buy the cereal for that reason. And if they say this is delicious, that's a matter of opinion, but it could actually, to the extent it's fact, it could be accurate. That's what makes these foods dangerous, right, is they are delicious. If they tasted bad and were bad for you, nobody would eat them. So I think the lawyer advertising cases, if anything, cut the other way.
Thank you. And then one more question for Jacob. You mentioned the Administrative Procedure Act rulemaking authority, but my understanding is the FTC has a different rulemaking authority that would take more like a 10-year period. And could you talk to that?
Excuse me. I don't think there's a temporal specification of the FTC rulemaking, and so like
I meant historically, it's taken quite a long time.
So like other agencies, they can be very involved. The rulemaking, informal or formal, could take a period of, you know, sometimes 3 years, sometimes 8 or 10 years, sometimes 3 months, and that's. I don't know why the rest of you didn't laugh at that. And you know, the pace overall, you know, we've done some work on this. Sometimes for some rules it's quite long, sometimes for other rules it's quite short. I think there is this idea out there that for an agency to do anything, it takes a decade. And you know, what a waste of time. And that's just not true. You know, it turns out that's just not true, even once you factor in litigation. Now, it surely is the case that with higher profile, higher controversy matters, involving many, many more players and parties who care, the comments that you'd receive, for example, or the participants that would want to be engaged and then subsequently challenge litigation go up. And there's no question about that. And I hope the takeaway from the talk is not that I champion or expect the federal agency to solve this issue. I do not. But I think there's legal authority to do so, and we should understand that as part of the overall context in which we are operating. That's all.
Thank you. Are there any questions from the audience? There's a microphone coming your way.
Yeah, question for Jacob. For those of us who prosecute false advertising by large companies, what do you see in your current research and collaboration as some current issues that might be ripe for prosecution, say, by energetic state-level prosecutors? For example, the mounting evidence against sugar as, contributing to so many chronic diseases, and just, are you seeing something that, do you have like a wish list of, what some state-level prosecutors could go after as misleading?
Yeah, I mean, I think the short answer is no, but it kind of exists already. So I think if you just look at the litigation in the California courts right now, it will cover, probably 90% of the things I could imagine suing companies for false advertising or false labeling or deceptive product claims. It's true in some other states too, but it's clearly happening here. Now those primarily are civil suits, to be clear. They're not brought by the state AGs. Depending on state law, they could be. I suspect in California, yes, but I don't know that body of law quite as well. But between New York and a handful of other states, we have seen a massive influx of class action attorneys, plaintiff side lawyers, into this area. My view is they have not yet found a theory that will get them home, but they're trying everything you could possibly imagine. I'd be shocked if, I'd be shocked if one or two of these cases and then subsequent ones don't come back for the plaintiff side, but overall to this point, I would not say they have not been wildly successful. What might change that significantly is if the companies hadn't withheld information, for example, like the tobacco and nicotine addiction issue, if there were parallel documents or ideas with respect to sugar or some other like ingredient, that might really sway whether it's particularly legally relevant or not, but now I'm just speculating.
Jacob, I wanted to ask you a follow-up question. There are lots of advertisements out there of all sorts, but let's assume that there were no advertisements that would be considered misleading under the definition of misleading that most lay people and judges would likely accept, which is somebody lying or suggesting something about health that was not sound. And let's say that therefore all of the promoters of junk food couldn't downplay their sugar. Maybe even, they could say some number of grams of sugar. I'm not sure how much that means to a 14-year-old. But in fact, what if they started saying, yes, our Twinkie has lots of delicious sugar. What practical effect do you think that would have on consumption? Do you think that would actually materially change the habits of kids in a way that would lead them to consume less sugar? Either by changing parents' decisions or kids' decisions.
The short answer is I'm not sure, but we can find out. And so one of the things that I should mention is Steve Ansala-Beher, who's in the government department at Harvard, and I are now doing an annual food survey where we do a lot of experiments with labeling particular claims like this and ask about changes in perception of the underlying products and also reported purchasing behavior. So when you see, for example, the grams of sugar, what effect does that have? When we add the percentage of the daily recommended amount of sugar, what effect does that have? Those results are just starting to come back. We have scattered results on sugar, on GMO, on percentages. Some of them, they're not as, well, let's just say it's preliminary. But it's an easy question to ask and answer, honestly. And there's no reason we should speculate. We should ask and answer that question. And if it turns out that a claim like that is, I take it truthful, because we've specified, we've opted out of the fraudulent or deceptive claim, or at least it could be deceptive truth, which is a real class category of conduct. But if it's a truthful claim that is then material and impacts behavior, we'd ask, does that in fact behavior? And I take it, you're not suggesting that does or does not allow for a legal claim against that company. You just want to know what effect that would actually have on the consumption by kids.
My suspicion is people talk about misleading claims, I'm sure there are genuinely misleading claims out there that I'm happy to see suppressed. But my suspicion is that a lot of what's going after this is the sense that, well, either if only we could get people to know the truth, they'll say, oh my God, there's all this sugar, I really don't want it, as opposed to, yeah, sugar, that's what I want from my food. So my suspicion is that some people are exaggerating the degree to which people, once they learn the truth, are going to really change their habits. My suspicion also is that there's some attempt to try to use this misleadingness argument as a way of suppressing even perfectly non-misleading ads. as a way of trying to persuade judges, oh, well, you know, you can shoehorn this restriction on something that's not misleading, we just don't like it, into the misleadiness.
The latter may happen on the former, the data we have, and I suspect others have similar data or know about other data in the room, is that a significant difference in sugar across two identical products or product labels significantly impacts the extent of willingness or desire to purchase. I can pull the exact numbers for you, but that's what we've been finding.
Actually, UK Mars, that is an advertising campaign they're doing there. It's saying like this is a sometime treat. So I don't know, maybe somebody's analyzing it. But I'd like to talk to the AG later. Yeah, there's a.
Hi, yes, I'm Katie Pratt from Loyola Law School, and I'm a tax expert. So I'm wondering about the role of tax proposals to several of the problems we've discussed. So if one of the problems is exposure to marketing, there's a tax proposal we could make. We could extend the period of time over which marketing expenses are deductible. They're currently deductible in full in the year in which incurred, whereas other investments in income-producing assets have to be capitalized and deducted over a 15-year period. So short of eliminating the deduction, we could increase the period of time over which marketing expenses are deductible, thereby increasing the price of marketing, which would reduce exposure. We could also make a tax proposal to encourage reformulation of products. We could tax unhealthy foods, not just soda, but we could provide subsidies to healthier foods to encourage reformulation. And of course, we'd have to start with some type of classification system. So to avoid problems with cross-border transactions, I think we'd need a federal system of food classification, something like front of package, stoplight labeling. So I'm wondering what the panelists see as the role of tax in regulating as opposed to command and control regulation.
I think the policy panel is going to be talking about tax a bit. Also, Rosa DeLauro had a bill about taking away the tax deductibility of the marketing of unhealthy food.
I will say it doesn't avoid the constitutional question, it recasts the constitutional question. That taxing speech precisely because you want to have less of it, or removing a tax exemption that is generally available to most business expenses. Business expenses are generally tax deductible. I'm not a tax expert, so I can't give you all the details, but usually the things you do to sell something are tax deductible, so you remove that, but precisely because you want to have less speech, the courts see through that and say, okay, it's a speech restriction. It may still be a constitutionally permissible speech restriction for some other reason, but there have been attempts to recast speech restrictions as taxation, and they've been struck down on those grounds.
May I respond to that? My proposal
Take the mic if you'd like to respond, please.
to eliminate the deduction. Sorry. Okay. My proposal is not to eliminate the deduction because I think that sort of objection could be raised because business expenses generally are deductible. My proposal is to put marketing expenses on exactly the same footing as the deductibility of other legitimate business expenses that produce a capital asset, something with value beyond the close of the current tax year. Under current law, the deductibility of marketing expenses is tremendously tax favored relative to expenses to create capital assets. Originally, marketing was immediately deductible because we were talking about the cost of placing a newspaper advertisement saying, sale this Saturday. Now marketing expenses are primarily to create branding, which is a capital asset, which should be amortized like all other investment in income-producing assets. So it should be amortized. The delay in deductibility increases the price of the marketing. So I'm not talking about eliminating the deduction. I'm talking about reducing the tax savings in present value for the expenditure by increasing the period of time over which it's deductible, which is consistent with all other capital assets which have to be amortized.
So I had thought that there was a suggestion, at least in the alternative of as actually denying deductibility. Maybe I misheard. Look, this is a common issue. You can sometimes characterize the same thing in two different ways. There are plausible arguments, presumably, why advertising could be seen as normal, ordinary expenses, because it also is supposed to just bring about more sales tomorrow, the same way that hiring more salesmen may do it for other businesses. It might be seen in some other way. I will say, it's an interesting question to what extent legislative purposes make a difference in constitutional claims. There's actually some interesting and complicated case law. But when the judge looks at it and says, this wasn't part of some overall attempt to rationalize the standards of capital, treatment of capital investment, it looks to me like somebody was trying to suppress speech that they don't like, or let's not say that, have less speech that they don't like. So they found this lever. My sense is the judges are going to pay attention to that. But it's true, if you could point out to them that for some reason this was always a departure from basic sound tax logic, and just now we happen to discover it, and now we're going to return to this underlying tax logic, maybe you might persuade them, sure.
Do we have a question up here? If someone could bring the microphone, please.
I think this tax proposal just made a very clever one, but I take it, it's a good idea on its own merits as a policy matter, but I take it would apply to all marketing, not just speech advertising, and it would also apply to all products, not just junk food, so that you run into a lot of other political opponents of it as well, not just the food industry. But I think it's, it sounds right to me as an economic matter, to change nature of marketing, and I don't think it would be just speech advertising. But then, I think it's there's my idea that it's clever.
You're right. The broader it is, if it applies to all marketing, then sure, that would have less of a First Amendment problem. But you're right. I was assuming that wouldn't be so, because it would be a pretty difficult political challenge.
Speaking of difficult political challenges, Steve, I'm not sure how you can get that kind of legislation passed of having a cap, if not trade, regarding junk food marketing to kids. But, and then also you suggested that might be an alternative to the 1,000 bees that Marlene is going to sick on the food industry. They're not mutually exclusive, and we have an interesting example that of something that's happening voluntarily along the lines that you're saying in the soft drink industry, where the soft drink companies have set a goal of a 20% reduction in calories that they sell by 2025. And in Britain, they have a quicker schedule of reductions, that it might be 25% by 2020. And then just last week, PepsiCo announced that it was going to change its, on top of that, a voluntary reduction, they're going to aim to have 3/4 of their beverages under 100 calories per serving. 3/4, now it's, I think, 40% or so. So in a way, that there is some voluntary movement in exactly the direction you're suggesting. I haven't seen the candy industry, and I'm not sure what other products you would consider junk foods, but at least there's some progress sort of along those lines.
I just note, when we say voluntary standards or voluntary guidelines, we don't ever mean that. There's no voluntary standard adopted. There's a standard adopted by private industry or private parties in the shadow of government regulation. And the question is, what is the threat on the other side such that private parties decide to engage on a particular scheme of self-regulation with particular standards? And what the government will or won't do is partially a function, of course, what the public is talking about and interests are talking about. But to think of it as voluntary and apart from that shadow is, I think, not entirely right.
I think the more people that would get behind my proposal, the more we'd have voluntary, we know that the industry did agree to reduce the amount of, the processed food industry agree the amount of calories that they sell. And they've more than exceeded their goals. Now, it turns out that actually, given the nature of the industry, they probably they probably didn't change anything because they were headed in that trajectory anyway. But nonetheless, that we see, and I think this is right. I mean, if Pepsi would agree not only that 3/4 of their beverages are less than 100 calories, but they actually agreed that 3/4 of the sales were beverages under 100 calories, I'd be more excited. But anyway, I think that's good. I think that this is this also reflects the idea. Let them decide what their range of products are. They'll sort it out. If they can meet these goals, these are the goals we ought to be excited about them heading towards.
And Marlene will still unleash her 1,000 bees and say it's not fast enough. And I think that's appropriate.
So Stephen, I want to ask you, are you coming for my steak? I mean, that's what a lot of people outside this room really suspect is going on. That there's talk of restricting advertising to children. That sounds very aggressive, because for all your children know any better, maybe we should restrict it. But then, the suspicion is really what we're after maybe banning them. Some apparently, the aliens that Jacob admires seem to say that.
We're not friends. I just know them.
So maybe that suspicion is well founded. And as I understand it, Stephen, your proposal, maybe Walmart would have to restrict what ends up being sold to children, but the person who consumes probably more junk food than anybody else in my household is my wife, who's an adult, who knows what she's doing. She's not obese. She's probably would be healthier if she ate a little bit differently, but she's choosing to enjoy life in a particular way. My sense is your proposal would end up interfering with her ability to do that. But of course it's just for junk food, and really we all know better. But my suspicion, or at least the suspicion of others, but in this case I would agree too, is it starts with the Doritos, and then eventually it's the steak, and eventually it's all these other things. So that's why I think there are a lot of people, when you talk about political problems, a lot of people have political reaction to this, because they feel we know where this is heading. And where this is heading is pervasive attempts to change through restriction, through making it much harder for not just children, but for adults to eat what we want to eat and make the unhealthy choices that we want to make. Now, tell me that's not where it's going.
It is going there. That's where it's supposed to be going. But the thing, that's the point. But the thing is, no individual choice is being prevented. Your wife could still eat as much as she would want. Walmart would have to change what
So what would she get?
No, she'd get it at Walmart. She'd get there. No,
but Walmart would know that if it sells enough of that, then it's going
to. So maybe your wife, who's got the very high demand, she would continue to do it. That's one of the criticisms of my proposal, that a lot of the people who are the most unhealthy would continue eating like they do, and other people would eat a lot less, because it would be a national. But if you look at, you get the national. In my view, it goes like blood pressure. If you could reduce the national blood pressure by 5 points on the blood pressure, you have a huge population impact, even though people with very high blood pressure may not get much reduction at all. You still get a big population gain. We don't observe it very easily, but it turns out we get that. And the same thing here. We try to leave individual freedom as much as you can. We try to have overall population health improvement. And that's what we're trying to achieve, I think, exactly right. So we'd let those people care about it, but overall, we'd have this national dietary gain. That's what public health is generally about, trying to have a population effect on the society as a whole, and try to leave people individually some freedom to do with it. I think to get down to zero would be ridiculous. That would be really bad, I think, to take away completely.
So I appreciate
I concede. I guilty.
So I'm happy to hear
not steak. Not steak.
So
steak is not a junk food.
I'm happy to hear you're trying to leave people individually some freedom. I'm sure people will be really satisfied by it.
Can I take the question? There was a woman all the way in the very back. Does she still have a question? Okay.
I do, thank you. Going back to the discussion about unfair and deceptive advertising claims under the Lanham Act or under consumer protection statutes, the courts use a reasonable consumer standard, so whether the advertising or label is likely to deceive a reasonable consumer. So, but this whole conference seems to be focused on kids and the special vulnerabilities of children and advertising targeted to them. So if the reasonable consumer standard is based on, I would imagine, an adult, do we need a new legal framework, or within that standard, can we deal with segments of consumers? And then my second question is in terms of injury, because if the parents are doing most of the purchasing, then how, from a legal standpoint, how are we going to protect children and their interests when they're not actually making a purchase and they're not necessarily deceived?
Yeah, so these are both really good and challenging questions. On the first, in this area of the law, but also lots of other areas of the law, when we think about a reasonable person or a reasonable consumer, the first thing we have to do is figure out what class we're pulling that reasonable person from. And sometimes that's a very narrow class, sometimes it's very broad, sometimes we mean all consumers or people in the market, sometimes we mean a reasonable 12-year-old or 13-year-old or 8-year-old. And so in different contexts, in different statutes, in different cases, I can easily imagine, I think the courts have focused on a reasonable kid, for example, or a reasonable teenager, sometimes different. So I don't think that's an unsurmountable problem, but to the extent that you are focused on one class of individual and the harm is done to another, obviously that's not going to work. Now, with respect to the injury, a way of talking about the scenario you described is sort of one of, I guess, third-party interveners. So there's a person who did something, then there's some other person in the chain, and then there's the person who got injured. And what we're asking about is, what are the permissible set of causes? How do we think about causation in that scenario? And often in the law, we say, no, if there's a third-party intervener, that breaks the chain of causation. If you committed wrong, but a third party comes in and does something wrong in between that and the injury, then you're not responsible. But we only do that sometimes. And the question is, when in the law are we going to describe a wrong and an injury as having been causally linked? And I think most people I talk to about this think, geez, it's a little crazy, maybe a little crazy, to say, well, that advertising for that product caused this injury, that is to say, this obesity or blood pressure or health effect. And that's kind of right on the law. On the other hand, if that didn't cause that conduct, they wouldn't spend billions of dollars advertising. You're generating exactly the behavioral response that is intended to be generated, and it results in exactly the predictable injury or harm. So the question is, what, in courts or law or juries, ought we do with that chain of causation? And I don't mean to say it's an easy question for the law. It's not. It's hard, but I don't think it's easy on the other side either.
Can I just add that the FTC does have a history of addressing, in the 70s, marketing to children for products purchased by adults, Wonder Bread, cereal, and vitamins. So they do recognize that the marketing is addressing the vulnerability of a child, even though the adults are likely purchasing the products. I think we're out of time. Okay, we're out of time, but thank you so much to our panelists.